Good afternoon, everyone. I must say, when I hear that I'm now going to jump into FERPA in front of a room full of entrepreneurs, I get a little chill, because certainly this is probably not on your top 10 list of things to find out about. But by the same token, I've made my living now for a number of years working with technology and IP-focused companies in closing commercial transactions. And I do understand that for a lot of you, FERPA and that other alphabet soup of statutes that govern what you do, those are not, it sometimes can seem like they're obstacles in the course of setting up your business and closing those contracts that you need to have. And it's my job, and this is a little level setting as we go through this today, I want to give you some basic tools so that when you look at it, maybe we see a little bit of an obstacle, but perhaps in some situations more of an opportunity if you understand exactly what the law is supposed to do for the districts and the schools and the enterprises that are required to comply, and also how you can work within that statute to achieve some of your business objectives. FERPA. I still remember the first time I heard FERPA. It was, maybe 15 years ago, and we had a client who was setting up something in the tech space, and they started to rant and rave about FERPA. And I thought, FERPA, this is back when I was starting to get involved in privacy. And what the hell is that? So I started to look at it and began to learn about it. And so I've had the opportunity, or the privilege, if you will, of watching how FERPA has evolved along with the technology, along with some of the societal concerns that we now have to deal with in the education space. It is the primary federal statute that governs student education records. And we know from Jules that there's a plethora of other laws and statutes at the federal and state level that also impact this area of business. But we're going to just focus on FERPA for my segment. Remember paper records? Anybody remember fax machines? All right, it predates that. And both the incentive and the hammer from the Department of Education is that all schools, and I'm going to use the phrase schools as a shorthand here, all schools that receive funds through the DOE have to comply with FERPA. And of course the velvet hammer is, if you don't, no money, right? Now, just again, to give you some basic tools, surprise, surprise, it's a complex federal statute, and it operates within a tight structure, relatively tight structure, with numerous defined terms. I think it's critically important for you to understand just 3 or 4 of the very top and most important ones. Education records. Those are records directly related to a student and that are maintained by an education agency or institution, and this next piece is us, or by a party acting for the agency or institution. So that's us. Education records have basically 2 types of information in them that we're going to talk about today. The first one is what's referred to in the statute as personally identifiable information. And that is, as we all know, the litany information that alone or in combination is linked or linkable to a specific student. But not everything in the education record is PII. Directory information. This is the kind of thing that might appear in the local newspaper about your son or daughter and the academic honor they've achieved, or the team that they are on and they're winning. These are things that, generally speaking, would not be regarded as harmful or an invasion of privacy if they're disclosed. Now, disclosure. Oh my goodness, if I had a nickel for every time I've heard this word used improperly. Disclosure means to permit access to, or the release, transfer, or other communication of personally identifiable information. That's where the focus is, and that's where the concern is. And it's by any means, electronic, paper, any other way, to anyone except the party that provided or created the record. So reading between the lines, it's the disclosure of PII outside of the school. FERPA governs the disclosure of education records to ed tech providers, that's us, as well as their use and subsequent disclosure. FERPA privacy rights apply to parents until they're 18. I have twins, they just turned 18, they've already informed me, they're young adults, so I guess they have these rights. FERPA gives these parents and the students some certain basic rights: inspect, review. This is one of my favorites, a very basic right. They have the right to request that inaccurate or misleading information be corrected. If it's not, there's a right to a formal hearing. If the hearing result isn't satisfactory, they have a right to put information in the education record that points out what they believe to be the error. Now, here's where we often run into issues associated with the contracts and the commercial transactions that you want to close with schools, okay? Basic rule, schools can't disclose information from the education records without parent or applicable student consent, except in some narrowly defined circumstances for specific purposes. School officials, scholarship money, the next school, that kind of thing. For audit or evaluation purposes, financial aid, judicial order, health and safety, and there are several others. Carve-outs. Carve-outs that we see as being relevant or possibly relevant to us. This notion of directory information, and remember, we define that, or it's defined under the statute, as information where if it's disclosed, it's not regarded as an invasion of privacy. So that can be released by the school without consent. Nonetheless, though, parents, students must be notified of the data points that a school proposes to include in directory information, and then have a reasonable opportunity to refuse the disclosure. And this third one, schools must notify parents, students annually regarding their rights under FERPA, with the method of notification at each school's discretion. I've raised kids all the way through from kindergarten. I cannot recall ever seeing a FERPA disclosure, but I'm sure it was there. Maybe it was online in the student handbook. I don't know. I'm sure I got it. It was somewhere. But the method of disclosure is left entirely up to the school. Somebody else actually see one? Is that what that was? I never saw one. I'm sure it was there. All right. Now this is a very interesting one because I get questions about this all the time. Ed tech, you know, we're technology companies, so you bring to the table this notion that as you provide your service, especially a SaaS service, right, which is what not everybody, but a lot of people have a SaaS service. So when you do this, you collect certain data. Data comes into your shop. You know what you have. You want to organize it. You know where it's coming from. You're accustomed to having at least some kind of quasi-proprietary interest in the data that you have. And you also have a feeling that you want to run your own business. So when I have clients that see this phrase direct control in a contract, they're horrified about this, right? Now, before I talk about the details of this carve-out from the rule that consent is required, let's talk a little bit about this. I'm going to put a school hat on, okay? School has an absolute obligation to comply with FERPA or they don't get money. Pretty easy. But what that means as well is that the school is also responsible for ensuring that its array of service providers, contractors, IT vendors, they're also required to ensure that those companies and individuals comply with FERPA. Hence the notion of direct control. They want to make sure that what's happening won't get them into trouble or lose them their funding. So this particular exception allows disclosure to school officials without consent, provided that the officials have legitimate educational interest. Now, from our standpoint as an ed tech company, we are deemed a school official only under certain circumstances. And the first one there is the hardest one. The school would otherwise have used its employees to perform the services or functions. So if you think of the school as having two hands, basically one hand would have been doing what you're doing, right, except they outsourced it to you. And that leads us to the second leg here, which is that the ed tech company has to operate under the direct control of the school. Very tight. You can only do exactly with the education records, the personal information rather, PII that you receive, exactly what the school permits. And also, the ed tech company agrees not to further disclose PII without consent unless the recipient meets another one of the statutory exceptions. So this exception is narrow. It also circles back because no further disclosure of the PII can happen unless the party, and we're going out now, we're tertiary, right? We have the school, we have ed tech, and then we have somebody we disclose it to. They also have to agree not to disclose it or have to follow it. Okay. But ed tech, right? We hire data centers. We might want to keep the data in the cloud. I mean, we have all sorts of third parties that we use, right? We have consultants. We don't need them all the time. They come, they go. It's a tech company, right? So just as the school is responsible for making sure that we comply with FERPA, ed tech companies, right? ed tech companies, we have to make sure, so we don't get in trouble, that our array of service providers also have taken steps to prevent the further disclosure of this data, right? So this, you know, they're all like this. We always have that middleman kind of thing, but this is a tough one in my opinion. In 2011, there was an amendment to FERPA in order to protect, quote, the privacy of education records while allowing for the effective use of data. Finally, there was a recognition that companies that work with data have a value add to provide. And so the DOE took the position that the new regulation broadened the ability of schools to disclose student information to private companies to help facilitate research and evaluation of education programs. So this is was an incremental step forward. Specifically, the regulation stated, and I do think as we try to take advantage of these exceptions, it's worth sometimes looking at it. An educational, that's us at school, may disclose PII from an education record of a student without consent. This is us, organizations conducting studies for or on behalf of educational agencies or institutions to develop, validate, or administrative predictive tests, administer student aid, or improve instruction. This C, improve instruction, is the one you can drive a truck through, all right? Because the program that you're going to provide, or the system, or the services, you know, clearly they're there to help something, to improve something. So this was a good thing from our standpoint. This created what I think is a legitimate opportunity for private enterprise to operate within FERPA. And here's the phrase, they crunch data. But there was an acknowledgement of value add, potential value add by what our companies do. And also, as you look at this, we don't need their consent, but they also don't get an opportunity to opt out. And that's critical too, because, you know, even for directory information, they get an opportunity to opt out. So to get these rights, though, even though I love ed tech applauded, right? It's 20, okay, now we can do this. So none of these benefits, you know, I heard somebody say the other day, well, FERPA giveth and then FERPA taketh away. You're not going to get these rights without having some sort of a quid pro quo here. So here we go. In order to fall within this exception to the prohibition on disclosure without consent, school is required to enter into a written agreement. Now, our case study later today talks about one of these agreements, but we've gotten MSAs from school districts, and I don't know, they're like monster documents, I think. And these agreements are very, very tight, and they're tight for a reason, and sometimes they're not negotiable. But in any event, in order to fall under this exception, you have to have an agreement that specifies the purpose, scope, and duration of the studies and the information to be disclosed. This has to be fairly specific in nature. So we might look at a commercial engagement, well, they're going to purchase the services from us for the next 5 years. You know, well, maybe 5 years is too long. You know, or the study might not take 5 years. You know, they're interested in looking at this many times on a segment by segment basis. How long is the study? Requires the organization to use PII only to meet the purpose or purposes of the study as stated in the written agreement. So there's a very tight regulation. They don't use the phrase direct control, but there's clearly very tight regulation on what you do with the PII. The study itself has to be conducted in a manner that doesn't permit personal identification of parents and students by anyone other than representatives of the organization with a legitimate interest. This gives new and stricter meaning to the concept of need to know. Because when you're running one of these operations, you're going to have employees, you're going to have independent contractors, and again, we have the data center, and I'm sure many of you can identify other folks that we need to hire to do this. So that means even within the universe of entities and individuals that help you provide their service, you have an obligation within that to make sure that no one has access to the PII unless they have a legitimate need to see it. So for example, does your R&D team really have to have access to the data? Maybe dummy data would do as well. But depending on how your organization is structured, these are questions you might have to find yourself answering. And this is the kicker. It has to be destroyed, all right, when it's over. When the information is no longer needed for the purpose stated in the contract, it has to be destroyed, and the contract itself will specify the time period within which the information may be destroyed. Now, this for many clients I've dealt with, is a very difficult clause for them to see, and here's why. Ed tech companies, like technology companies across the board, many times view the information that they've received as a separate commercial asset. Now, ed tech companies, somewhat less, because you go into the business, you go into this vertical knowing that you have a strict regulatory structure, just like they do in healthcare, where they have to deal with high tech. Now, just to shift gears for a minute, under high tech, HIPAA high tech, there's a very strict protocol for determining whether data has been de-identified. And once it's de-identified, sky's the limit, right? And it's a very strict test, but it's doable. And so many companies in that industry, tech companies, have mastered the notion of de-identifying the data and knowing how they're going to use it. Now, question, let's put aside for a minute what exactly de-identified means, right? 6 degrees of separation. But for purposes of our conversation today, under HIPAA high tech, you can de-identify, very strict rules. In the case of FERPA, the rule is much less well defined, which is both good for us and bad for us, because FERPA permits the disclosure of de-identified records and information without consent, subject to the following: removal of all PII. Well, what does that leave us with? All right, removal of all PII, provided that the school or other party has made a reasonable determination that, and there's a typo, that the student's identity is not personally identifiable, whether through single or multiple releases, and taking into account other reasonably available information. So nothing hard about that, right? We just have to remove all the PII, take a look at the universe of other data that's available, and conclude that there's no possible way anybody could identify this student, okay? Now, this is I think, a little bit of a tricky definition, but you do have some protection here by the notion that you've made a reasonable determination. So if you decide that you want to pursue de-identifying some of the data obtained from education records, make sure you document how you approached it. Take a look, think about how you want to do it. And what many companies find just as useful, or useful as well, I should say, is anonymous data that you gather, right, from the aggregated anonymous information. So sometimes you can spot trends, but again, that is a rocky road when it comes to students, because that's when you start running into the presence of other statutes. So if you're going to de-identify, document it, and you might want to look at some of the other statutory structures out there for de-identifying data for guidance. And I actually like this one. You can de-identify student-level data from education records for the purpose of research, which again is one of those nice terms, by attaching a code to each record that allows matching the record with information from the same source. Reading between the lines, it would allow the school to match that information to their student records. This code that's attached, though, comes with some conditions. You cannot release any information regarding how the codes are derived, where they come from, how they're assigned, or that would allow a recipient to identify a student based on a record code. Sound a little bit like COPPA there, right? They're looking at treating it that way. The record code is only used to de-identify a record for education research. So it sounds to me like you should have a contract in place with a district authorizing you to conduct some research if you're going to do this. And the record code obviously can't be based on the Social Security number or other personal information. So we're talking really here random codes assigned. So there is some limited opportunity with that. So moving away from the carve-outs, at least those are the ones I see most often in the commercial type transactions that I deal with. And by the way, with those types of commercial transactions, there are multiple threads, right? And they all sort of collide, and you have to measure the relative importance of each of them, because you have your commercial deal, right, the revenue streams you want to get. You have the issues associated with the technology itself, and those in the contracts can be extremely strict, right? Including security, how it works, how people log on, all of the things that go through that, encryption issues. And then the third leg on the stool here in these types of transactions is really the privacy and the data security. So as you look at each of the issues in these matters that you're pursuing, those are really the three things you have to keep in mind. you know. And so each of these, I like to call it 3 legs on a stool. One of my kids told me, no, there should be 4 legs on a stool. My stool has 3 legs, okay? So when you're looking at these 3 legs on the stool, there are risks attendant to each of them. And so the sort of the game plan is evaluate the risk, mitigate risk, and decide what you can do. Now, FERPA doesn't authorize a private right of action specifically, or at all, really. So individuals can't file actions directly against the government or schools. Now, none of this means that the school board can sue you in a heartbeat if you breach your contract, all right? So that's not what I'm talking about. This is one, this case back in 2012 actually was an organization contesting the 2011 amendments we just talked about. And it got summarily thrown out because of lack of standing. So you don't have standing. That doesn't mean that people haven't tried, okay? People try all the time, all right? Although because of that prohibition, there's not as much litigation or administrative procedures, which is what the other one was. There aren't as many of those as there might be in other areas. I'd be shocked if anybody in the room hasn't heard about Google, right, and the apps for education. Scanning the Gmail messages and information for advertising purposes. Consumers filed a class action under the ECPA, right? We don't know whether it would have withstood the test of standing or they would have found a violation because Google, quite wisely, in my opinion, voluntarily agreed to stop the practice.
And how about ECPA is often considered sort of a wiretapping
Exactly.
statute, so you're like, wiretapping, what do you got to do with wiretapping there? But plaintiffs' lawyers have often used it to say, oh, you're intercepting the communication. Who are you, some third party in between the consumer and the website? So sometimes they fail, but gets people to court.
It's usually enough, right, it's enough to get the complaint. It usually is enough to withstand the motion for summary judgment. And once you've done that, you can bring people to the table, I would say, right? So that was Google. This I just wanted to mention because it so clearly followed after 9/11. And so this is a tracking database for people enrolled in certain schools. They can transmit information to INS. That's just an FYI. It's not really all germane to what we're talking about today. A minute on the Protection of Pupil Rights Amendment, PPRA, another one adopted in 1974, most recently amended by the No Child Left Behind legislation. PPRA applies to schools that receive federal funds from the DOE, and it governs the administration to students of certain surveys, analyses, or evaluations in 8 or so protected areas. What can be done with that data? Again, this is an informational process. I have seen very occasionally, I remember I had a purchase transaction not too long ago by one of our media companies, buying a company that appear to have never heard of this. So it's there, it's important, and in some instances it's not terribly well known, but you should be aware of it.
There's also a marketing problem, which I always like to point out, which doesn't get a lot of attention in PPRA. But if, in theory, a school was looking to let someone use data for marketing,
yep,
they need to declare that and then give people an opt-out. So I don't think you actually ever see that done often by schools. I don't know, correct me if I'm wrong. Have you seen schools declare, here we're going to allow, well,
not well known.
No,
and so a lot of FERPA, I'm like, there's a few no marketing without declaring and letting parents each time opt out of the marketing use. Doesn't get a lot of attention,
It doesn't get a lot of attention, and I've also, unfortunately, like I was thinking about this other transaction I had, I've seen many situations where the materials that are distributed, someone's gone to very great lengths to obfuscate the marketing purpose of the survey. And you might find the disclosure in a little print, in size 6 font someplace, but it's not, I totally agree with you, it is not well done and it's not well known. And that's really a shame, because what better way to understand a demographic than to send this out and promise them, a discount at pick your place, the movies, anything. So I find that troubling. Anybody in the room never heard of InBloom? All right, I figured as much. It'd have to be. For anybody involved in this part of the tech space, I personally was very excited by InBloom because it came so well funded. It's a wonderful idea. The goals, of the company, its organizers. I mean, it's phenomenal. I think, though, that the experience with InBloom has shown that it was years before its time. I don't know how many years, but years before its time. And it also showed, I think, a significant, still, disconnect between the capabilities of our technology and our ability to analyze data and, you know, people's willingness to do this when it comes to their children. You know, I mean, it would have to be a pretty high bar to assure people that this was going to be done properly. So, started out with great ideals. You could aggregate data across schools and state lines to assess effectiveness. What could possibly be better? You could cut that data any which way you wanted. They did receive a lot of attention. They even were hired by the New York State Education Department. The other one that I remember for InBloom is a district, I don't know why this one sticks in my mind, but a district out in Colorado, which also had its own tussle with InBloom. But within a relatively short period of time, and of course measured by how long it takes for these issues to permeate around the country, their projected success and all the different things that it could do with this data began to be overshadowed by these concerns. And you know, in this country, at least at this moment, very few things are more local than your school district. I mean, and people would show up at the local school board meetings, at the regional school board meetings, at the state meetings, and express their concerns. And in this space, even though InBloom offered this, they offered that, they offered many different, you know, indications, there was still an overarching concern. And I remember reading an article on one of these things, and a parent said, okay, so-and-so from InBloom made these promises. Even if I believe that individual, how do I know that that data won't fall into somebody else's hands at some point? And that's hard too. So there's a lot of concerns. This kind of issue, I think, also is in play around some of the business models that you all have. Because at the end of the day, whether you're, you know, providing a service, a SaaS service, whether your product and service line is affiliated with Google or, you know, any one of the big players, whether you're in the cloud, out of the cloud, you have your own database, whatever it is, I think that these kinds of issues are around the way that you do business. You have a PR issue that's there in a way, not there in a way for many other companies, because even if a company, I mean, what's the other type of entity that handles really sensitive type data? That would be healthcare. But a lot of what's going on in healthcare with, you know, electronic data, with, you know, the faxing, the texting, all these different things, that more or less happens behind the scenes. We're not, you know, we go into the doctor and we sort of know, yeah, it's electronic, and we have HIPAA, and I sign the form, and the data goes here and the data goes there. We're not really privy to it in the way that we are when we see it, the data being gathered from our children, and we have access to what they're doing on homework, and we look at it. So you have, I think, a relatively higher, I don't want to say barrier, but you need to be, I think, more aware of that than probably any other tech vertical in this space. And this is just my example for illustrating that belief. Now, looking forward, and I would hesitate to say that I have a crystal ball on any of this. I think Jules is probably in a much better position to make these predictions. A couple of things. The DOA did come out with a framework for protecting student privacy. Drew a lot of commentary. I think it was, my view, very well thought out, but I don't think there's any way to make everybody happy. This is actually a good way to be. We have a lot of public commentary. We have a lot going on, so the discussion itself is positive. Something else to watch and to be aware of this, and this kind of development is consistent with the sectoral approach to privacy that Jules identified. We do pick it place by place by place. We don't have a comprehensive thing. But what happens is a consequence of the federal government and not having a comprehensive privacy protection structure is that the states, you know, perceive a gap, and maybe they're right. So you have states jumping right in there to correct issues that are important to their constituents. So for example, just to draw an analogy again to HIPAA and high tech, did you know that Texas is one of the few states in the country that has a HIPAA type law that is stricter than HIPAA? Did you know that? They actually go so far, and this is Texas after all, right? But they actually go so far as to seek extraterritorial jurisdiction over data collected in Texas. It is incredible. So the states, especially the more activist states, will jump into this. And that makes it very complicated depending on which district you're dealing with. So California now has this law, the Student Online Personal Information Protection Act. I'd really like to know who comes up with these acronyms because I'm in the wrong business. I can do better than that. But this was passed. It prohibits operators of online educational services, us, from selling student data and using the information to target advertising to students or to amass a profile on students for non-educational purposes. So what does that do to a situation where you have codes, you want to match codes, you have to have this? I mean, we're going to see how this works out. But that would be a goal for a lot of companies in this space, and I'm getting the high sign here, so I think I don't. There is a piece of federal legislation. This was intended, as far as I know, it's still pending unless someone has some additional information. I think it's trying to push FERPA closer to what has been done in California.
Let's grab some questions with you. We're going to drill down into.
Yeah, he was waving his hand. I think that means.
And we're going to drill down into where things are going legislatively. We'll see
Later,
soon,
right?
Later on. So let me, if I can, maybe
that was it.
Invite
that was actually it.
Folks to flag or raise any questions with any of the FERPA details that you heard today.
I hope it wasn't too boring. Going through FERPA is tough. Yes.
No, unfortunately, this stuff is riveting.
Yeah.
So I guess one of the biggest takeaways that I got from this is that as long as we remove anything distinctly identifiable about the student and replace that with a unique number, we can basically keep and continue to analyze all the data, so long as it cannot be directly resolved back to.
If you de-identify data, and that was the standard that I put up on the screen real quick, and if you want to do that, you should go look at the actual statute, because I paraphrased it a little bit. So if you de-identify the data, then you can use it.
So the flip side of that is if the school first replaces the data with a unique identifier, such as a system whereby even if a student logs in with a unique identifier,
right?
Does that bypass basically all these regulations if we don't actually know who is logging into our platform?
What you can do when you have a code, and assuming the school assigns the code, then you have access to the data. And whether or not and how long you can keep it and what you can do it for, I would go back and look at your contract when you're using the codes. De-identified, in my view, is the surer way to go.
So de-identified is something that I don't think we're giving it a lot of time here, but I will tell you, I think there's some fuzziness over.
Oh, absolutely. That's a fuzzy
not just
definition.
in this area, right? So clearly aggregating stuff at a decent level, right? Statistics are de-identified. And when you look at the guidance that the DOE gives, and so maybe we'll press Kathy Stiles when she's here tomorrow and see if she'll clarify. And so when you look at the guidance that the DOE gives, they really talk about aggregated type of examples, right? Which may be interesting and useful, but you're sort of saying, well, wait a second, what about what I'll call pseudonymous data, record level data?
Yeah.
And in the rule, they say, well, you can de-identify data, basically, and then they say, if you want to have a code in it, then here are the rules of how it can be used only for educational research purposes,
right.
And you're not necessarily thinking educational research purposes, right? Because if you are, great, that's the point of being able to track data over time. You're saying, well, maybe I might have another use of some sort. And so one of the questions I want to clarify with Kathy, and again, if anybody has a strong view, of course, your contract. The contract may say simply de-identified, which leaves open.
It will.
Does your vision of does the school's view of de-identified mean aggregated, summarized data where go ahead, you can report, how many, but wait, can I actually create a profile, or can I have longitudinal data to track, to target, and so forth? So, Jim, view, does the fact that the educational carve-out is where they say you can have a student code mean that aggregated data only is considered de-identified in the FERPA? Or is this an open question?
I think it's an open question. I think aggregated data, definitely, I would be extremely careful about getting data that has an identifier from a school. I don't think that the average school has the understanding of what that means. There's some very specific rules around student ID and when student ID, like in our district, well, everywhere, we specifically declare student ID as a piece of directory information in our annual notice. There's some very specific requirements about when we can use that as a login and what has to come up with it. And we look very carefully at our vendors for when they're displaying like student ID. A lot of districts will choose to use that as part of email because it's easy, but that can be a real problem.
And if you're somebody who's also or separately covered by COPPA, COPPA's got a different, more narrow definition because the FTC didn't want behavioral advertising, and so they knew, well, you don't need a name, you can use a cookie, you can use an ID, and so they explicitly said, yeah, that is personal if it's used to track across sites beyond the purposes of the operator. And boy, Lynette is gonna maybe help us understand exactly what that means. It primarily means certainly no behavioral advertising or creating a profile for some other purpose outside, but exactly where and how it fits or doesn't fit with FERPA de-identified is something I'm going to ask tomorrow.
This relates to this, but I work for the Privacy TA Center, the Department of Ed. They do define that. I work for Kathleen.
Please.
They define that on the PTAC website, so you can look up what de-identified means with the department. They put that out maybe a year ago. So before that, it was really ambiguous and very hard to understand.
Oh, that's great.
What is de-identified? So that actually goes through methods that they recommend.
And all of those examples, this is sort of what I've been either figuring out or getting reviewed. All of the examples that the statistical guru, who's the DID expert, Michael Howe, Michael,
HAUS.
all are what you might consider removing cells. I mean, they're all obscuring data. None of them look like to me that they would have allowed a unique identifier to continue to be in the data. But key issue.
I think it's a key issue from all kinds of standpoints.
Yeah. Go
Hi,
ahead.
Chief. I have a question about what direction the definition of marketing and targeted advertising is going. Because as students build out their profiles with many of the apps that I'm seeing, they're looking at providing differentiated support to the students, and that might include recommending certain, here's financial aid calendar that might be helpful to you, et cetera.
Right.
And I've heard some folks say that would fall under marketing.
What do you think, Jules? I think it could.
California says
Yeah.
targeted advertising based on personal information. The bills that are, the pledge says behavioral advertising, because we know everyone knows not to do behavioral advertising, personal or not, right? The industry that does targeted advertising knows what that is, so we said that. Because whether or not, I mean, I get someone saying no advertising, like it or not, I understand that. But once you say you can advertise, what does it mean for it not to be targeted? I have to show the 8th grade promotion to everybody, like what differentiation is or isn't allowed. And so this is going to be a key issue in, I think, the federal debate. Did I say, Jim?
And PPRA doesn't differentiate between behavioral, which is on us at the schools. That's
Right. And so what is a scholarship offer, perhaps, right, that is targeted?
Right.
It is an offer. Please learn more from our institution. I'm paying perhaps a guidance app or the like to display that to the scholarship students that I want to reach. And so I will tell you, when people have raised that to some of the legislators, they said, oh, well, we don't really want to stop that. How should we say it? And so, we'll raise that maybe when our friends from Common Sense Media and some of the advocacy folks say, well, where and how do you want to draw lines? Do you want to limit all marketing, advertising? What are the goals? And I think you'll sort of hear the range of concerns. So I think we have time for one more before we jump into topic. Yes, sir.
My name is Alex, who's involved in, perhaps we can talk about this another time, but can you just go into a bit more detail the notion of direct control or provide another example of how it's defined? Is it school by school in terms of how an ed tech product or something is, you said, taking the place of someone in that performance?
Let me give you an example. If you had after-school program, you bring in the Y to provide an after-school program. They're not, because they wouldn't ordinarily have had their own employees doing that, then that's not direct control, right? It has to be an activity that if you weren't doing it, if it wasn't being outsourced, there would be a school employee doing it. So yes, it is granular. Yes.
It's presumably not. Professor Joel Weinberg did a big study where he pulled, a number of contracts and said, look what they say. They say, we're sending you data, you promise to follow FERPA. Period.
Yeah.
That's clearly not direct control, right? And his critique was, and I think what people understand is, here's the data that you're getting, here's exactly how you can use it, here's what authorized purposes there are, and you can't use it for anything else, right? Those are
indicia of direct control, but it starts from the idea that ideally that it's something that the school district employees themselves would be doing if it wasn't being outsourced. But you're right, a lot of times those contracts just say comply with FERPA and God be with you.
I think she's a FERPA Sherpa.
Absolutely, thank you.
Thank you, Mary.